Parties to civil action. In Rule 3, Sections 1 to 22 of the Rules of Courts, we will know the following. Parties to civil action, parties in interest, representatives as parties, spouses as parties, minors or incompetent persons, permissive joinder of parties, compulsory joinder of indivisible parties, necessary party, non-joinder of necessary parties to be pleaded, unwilling co-plaintiff, misjoinder and non-joinder of parties, class suit, alternative dependents.
A known identity or name of defendant's entity without juridical personality as defendant. Death of party, duty of counsel, death or separation of a party who is a public officer, incompetency or incapacity, transfer of interest, actions on contractual money claim, an indigent party, and notice to the Solicitor General.
Who may be parties? Plaintiff and defendant. The plaintiff is the claiming party, or more accurately, the original claiming party, and is the one who submits the complaint. The phrase, however, does not only apply to the original complainant. It could also apply to a defendant who files a counterclaim, cross-claim, or third-party complaint, while the defendant is not just referring to the initial defending party. When a counterclaim is made against the original plaintiff, the latter becomes a defendant, while the former becomes a plaintiff in the counterclaim. Who can be parties? Only the following may be parties to a civil action. Number 1, he must be either natural, juridical, persons or entities authorized by law. He must have the legal capacity to sue. And third, he must have real property in interest. A real party in interest is the party who stands to be benefited, injured by the judgment in the suit, or the party entitled to the avails of the suit. Representative as parties. A representative may be a trustee of an express trust, a guardian, an executor, or administrator, or a party authorized by law. Spouses as parties. When a party is a spouse, the husband and wife shall be sued or be sued jointly, except as provided by law. When can a spouse sue or be sued independently, as an exception as provided by law? A spouse that can be sued independently through action involving the exclusive property of the spouse, property brought to the marriage as his or her own, that which each acquires during the marriage by gratuitous title, that which is acquired by the right of redemption, by barter, or by exchange with property belonging to only one of the spouses, and that which is purchased with exclusive money of the wife or the husband. A minor or incompetent person. Who is a minor? A minor is someone under the age of majority, which is defined as the age that distinguishes between childhood and adulthood in the eyes of the law, or a child under 18 years of age. Who is an incompetent person? An incompetent person may be defined as one whose mind is unsound, deranged, impaired in function, such as a slow IQ, deterioration, illness, or psychosis. A minor or a person alleged to be incompetent may sue or be sued with the assistance of his father, mother, guardian, and if there is none, a guardian ad litem. What are the requirements for the permissive joinder of parties? The answer is all persons in whom or against whom any right to relief in respect or arising out of the same transaction or series of transactions is alleged to exist, whether jointly or severally, in alternative except provided by these rules. Who is indispensable party? Indispensable parties are parties in interest without whom no final determination can be made whether an action shall be joined either as plaintiffs or defendants. What is the purpose of impleading an indispensable party? The presence of indispensable parties is necessary to vest the court with jurisdiction. Thus, without the presence in a suit or proceeding, the judgment of a court cannot attain real finality. Who is a necessary party? A necessary party is one who is not indispensable, but who ought to be joined as party of complete relief, is to be accorded to those already parties, or for complete determination or settlement of the claim, subject of the actions as provided in Section 8 in Rule 3 of the Rules of Court. What are the effects of non-joinder or misjoinder of a necessary party? The effects of non-joinder or misjoinder by a necessary party shall be as follows. A necessary party may be omitted in pleading, but the pleader shall set forth his name, if known, and shall state why he omitted. Should the court find the reason for the omission unmeritorious, it may order the inclusion of the omitted necessary party if jurisdiction over person may be obtained. If the court finds the omission justifiable, or even if not justifiable, but jurisdiction over the person of such party cannot be obtained by such court, then such omission will be allowed, and the proceedings shall continue despite such non-joinder. What is the rule in the case of an unwilling co-plaintiff? Under Section 10 of the Rule 3 of the Rules of Court, if the consent of any party who should be joined as plaintiff cannot be obtained, he may be made a dependent, and the reason, therefore, shall be stated in the complaint. Who is a misjoinder and a non-joinder of a parties? A party is misjoinder when he is made to the action, although he should not be impleaded, while a non-joinder when he is supposed to be joined but is impleaded in the action. What are the elements of a class suit? The elements of a class suit are as follows. Number 1, the subject matter of controversy is one of a common or general interest to many people. The number of people so numerous that it's impracticable to join all parties. The parties actually before the court are sufficiently numerous and representatives as to fully protect the interest of all concerned, and the representative sue or defend for the benefit of all. What is the rule on alternative dependence? Where the plaintiff is uncertain against whom of several persons he is entitled to reveal, he may join any or all of them as dependents in the alternative. Although a right to relief against one may be inconsistent with a right of relief against the other as provided in Section 13, Rule 3 of the Rules of Court.
What is the rule in cases where the identity or name of the defendant is unknown in an action? Whenever the identity or name of a defendant is unknown, he may be sued as the unknown owner, unknown heir, unknown devisee, or by such other designation in the case may require. What is the remedy in case the true name of the identity is discovered? Under Section 14, Rule 3 of the Rules of Court, when his identity or true name is discovered, the pleading must be amended accordingly. When one or more persons not organized as an entity with juridical personality enter into transactions, it has the following effects. They may be sued under the name which they are generally or commonly known, and in the answer of such defendant, the names and addresses of the person composing said entity must all be revealed. What are the duties of a counsel in case of the death of a party in an action that survived? Whenever a party to a pending action dies and the claim is not thereby distinguished, it shall be the duty of his counsel to inform the court within 30 days after such death of the fact thereof, to give the name and addresses of his legal representatives or representatives What are the effects in case of the death or separation of a party who is a public officer? When a public officer is a party in action in his official capacity and during his pendency dies, resigns, or otherwise ceases to hold office, the action may be continued and maintained or against his successor if within 30 days after the successor takes office or such time may be granted by the court. It is satisfactorily shown to the court by any party that there is a substantial need for continuing or maintaining it and that the successor adopts, continues, or threatens to adopt or continue the action of his predecessor. Before a substitution is made, the party or officer to be affected, unless expressly assenting thereto, shall be given reasonable notice of the application, therefore, and accorded an opportunity to be heard. What is the effect if the party to the action becomes incompetent or incapacitated? If the becomes incompetent and incapacitated, the court, upon motion with notice, may allow the action to be continued by or against the incompetent or incapacitated person, assisted by his legal guardian or guardian ad litem. Transfer of interest. A transfer of interest is a transfer of ownership of any object, real property, or business entity from one party to another. What is the effect in case of transfer by the party? In case of transfer of interest by the party, the court may allow the action may be continued by or against the original party unless the court motion directs the person to whom the interest is transferred to be instituted in the action or joined with original party. What is the effect in case of death of a party in an action based on a contractual money claim? It will not be dismissed but shall instead be allowed to continue until the entry of the final judgment. In case of a favorable judgment obtained by the plaintiff, it shall be enforced in the manner especially provided in these rules for prosecuting claims against the state of a deceased person. What are the actions that survive the death of the party? Action for the recovery of money arising from a contract, express or implied. Actions to recover real property, recovery of a personal property of an interest therein from the state or to enforce a lien thereon, and actions to recover damages for an injury to persons or property, real or personal, may be commenced against him who is an indigent party and is one who is allowed to litigate an action who has no money or property sufficient and available for food, shelter, and basic necessities for himself and his family. What are the requirements to be declared an indigent party? A party may be authorized to litigate his action, claim, or defense as an indigent if the court allows, subject to the following requirements. Upon an ex parte application and hearing, the court is satisfied that the party is one who has no money for property sufficient to provide food, shelter, and basic necessities for himself and his family. What are the effects of a party's declaration of indigence? If a party is declared by the court as indigent party, the authority shall include an exemption from payment of docket and other lawful fees, an exemption for the payment of transcripts of stenographic notes which the court may order to be furnished to him. When is notice to the Solicitor General required? The court in its discretion may require the appearance of the Solicitor General, who may be heard in person or through a representative duly designated by him in any action involving the validity of any treaty, law, ordinance, executive order, presidential order, and rules or regulations, who has the power to represent the state. As a general rule, the mandate or authority to represent the state lies only in the office of the Solicitor General.